You know, I was sitting in the airport the other day, killing time before a flight, and I overheard a conversation that genuinely made my stomach drop. A guy, probably in his early 30s, was on the phone with his wife, and he was panicking. He had just been pulled over coming out of the parking garage. Apparently, he'd had one beer with lunch, just one, and he was explaining to her that the officer had asked him to submit to a breathalyzer. He kept repeating the same thing the officer had told him. If I don't blow, I lose my license for a year. If I blow and I'm over, I go to jail. What do I do? What do I do? And my heart just sank for him because I knew, and I'm sure many of you know, that he was operating on a fundamental misunderstanding of what was actually happening in that moment. He was trapped between two terrifying outcomes, and he had no idea that there was a third door, a door that most police officers will never, ever tell you exists. So, here's my question for you. And I really want you to think about this. If you are sitting behind the wheel and the red and blues are flashing in your rearview mirror, and the officer walks up and says, "Step out of the vehicle. I need you to blow into this machine, or I'm taking your license for a year." Do you know, without a shadow of a doubt, what you would say? I'm not asking what you think you would do. I'm asking if you actually know the specific words that should come out of your mouth. Drop it in the comments. I'm genuinely curious. Because the answer might surprise you, and the explanation of why that answer is right or wrong is exactly what we're going to dig into today. Stick with me, because by the end of this, you're going to realize that the choice isn't nearly as simple as blow or lose. Let's rewind for a second and talk about why that guy in the airport was so scared. He was scared because he believed the cop. And look, I get it. When a police officer, a figure of authority, tells you that something is going to happen, your brain instantly treats it as law. It's survival instinct. You don't want to lose your license. For most of us, a driver's license isn't just a card. It's the key to our job, our family, our ability to live a normal life. The threat of losing it is existential. So, the officer uses that. It's the most effective tool in the toolbox at that moment. He creates a binary choice: comply and possibly face criminal charges, or refuse and face an administrative penalty. And he makes it sound like the administrative penalty, losing your license, is a sure thing, an automatic consequence of saying no. But here's where it gets nuanced, and where my years of traveling and researching this intersection of law and travel behavior really come into play. What the officer is doing in that moment is conflating two completely separate legal proceedings. They are as different as a baseball game and a hockey game, even though they both involve a stick and a ball. One is the criminal case, and the other is the civil or administrative case. When you are driving, you are operating under the implied consent laws of whatever state you are in. That means, by virtue of holding a license and driving on their roads, you have implicitly agreed to submit to a chemical test if you are lawfully arrested for driving under the influence. If you refuse that test, yes, the Department of Motor Vehicles, or the equivalent state agency, can move to suspend your license. That's the admin per se suspension. That's the lose your license part. But, and this is the massive gaping hole in the logic presented to you at the roadside, that suspension is not automatic, and it is not immediate. It is a process. It involves paperwork, deadlines, and most importantly, the opportunity for a hearing. The officer, standing there in the dark with the traffic buzzing by, makes it sound like the second you say no, your license is electronically vaporized. That's not how it works. They will take your license, sure. They'll give you a temporary paper permit, usually valid for 30 or 45 days. But that paper is your golden ticket to challenge the suspension. That paper is your entry fee to a hearing where you get to fight back. So, what should you say? This is the part that takes guts, and I want you to practice it in your head because the adrenaline dump of a traffic stop will make you forget your own name. You need to be polite, you need to be respectful, but you need to be firm. You look at the officer and you say, "Officer, I understand you are asking me to take a chemical test. Out of respect for the process and for myself, I am going to decline to answer any questions and decline to perform any field tests or provide a breath sample at this time. I am happy to comply with the booking process at the station, but I would like to speak with my attorney first." Now, watch what happens. The officer might get frustrated. He might repeat the threat. "Okay, but if you don't blow here, you're losing your license for a year." And you simply say, "I understand that is a potential consequence, officer, and I am willing to accept that administrative process so that I can preserve my right to counsel and fully understand the criminal charges I may be facing. I request to speak with my attorney." Do you see the shift? You are no longer a deer in the headlights. You are someone who understands that there is a difference between the roadside carnival and the courtroom. The roadside breathalyzer, the portable one they pull out of their car, is notoriously unreliable. Temperature, user error, radio frequency interference, they can all throw it off. More importantly, it gives the state a piece of evidence before you've even had a chance to talk to a lawyer. You are essentially building the case against yourself in real time on the side of the highway without any legal guidance. Let's talk about what happens next. If you refuse the roadside test, you will be arrested. That's almost a guarantee. The officer has already decided you're impaired, or at least he has reasonable suspicion to make the stop and probable cause to make an arrest based on your driving, your eyes, or the smell of alcohol. The arrest is happening whether you blow a .02 or a 20. The refusal just gives him a clean path to the station, and this is critical. At the station, behind those double-locked doors with the video camera rolling, they will ask you again. They will read you a formal implied consent warning, and this time, the stakes are real. But here's the secret. You've bought yourself time. You've had a car ride to think. You've had time to calm down, and you're now in a controlled environment where you can actually request to call your lawyer. The advice to refuse the roadside test is not about beating the rap. It's about managing the timeline and the evidence. It's about not handing the prosecution a neat, tidy, portable reading that they can enter into evidence before the defense has even laid eyes on the discovery. It forces them to rely on the more accurate but also more challengeable station test. And it forces them to articulate why they thought you were impaired based on your driving and your behavior, not just on a number from a plastic box. I remember talking to a prosecutor once, years ago at a conference in Atlanta. We were having coffee, and I asked him off the record what he hated to see in a DUI case. He didn't hesitate. He said, "A refusal to blow at the scene, followed by a request for an attorney." He explained that it immediately complicated his case. He had to rely on the officer's testimony and the video, which can be ambiguous. Jurors like numbers. Jurors want to see a bright line. .08 is a bright line. Without that number from the roadside, the case becomes a battle of, did he look drunk versus, was he just tired? It introduces reasonable doubt in a way that a 211 reading on a printout never can. Now, I have to issue a warning here because this isn't a one-size-fits-all situation, and anyone who tells you it is selling something. This strategy requires you to be sober enough to articulate your request respectfully. If you are falling down drunk, slurring your speech, and belligerent, your refusal is just going to be another charge on the list. The request for an attorney has to sound like a human being asserting a right, not a drunk person being difficult. There's an art to it. And let's talk about the license suspension again, because I know that's the part that terrifies everyone. That 30-day temporary paper is your lifeline. The moment you get it, you have to act. You have to request a hearing with the DMV to challenge the administrative suspension. And here's the kicker. If you win that hearing, your license is reinstated. And if the criminal case later falls apart or is reduced, you walk away with zero consequences. But if you had blown a .09 at the roadside and they got that number, you've already admitted guilt to the administrative body. The DMV hearing becomes a formality. You've already given them the rope. People also forget that the roadside breath test is not mandatory under the same legal standards as the station test. The implied consent law usually triggers upon arrest. Before arrest, you are simply being asked to participate in a field sobriety investigation. You can decline to participate in field sobriety exercises, the walk and turn, the one-leg stand, the alphabet, without the same penalty as refusing the chemical test. Those are voluntary. The cops will never tell you that. They'll say, "Step out of the car and do this test for me." And it sounds like an order. It's not. It's a request. You can politely decline. The confusion is by design. The system relies on compliance. It relies on the fact that you are a good, law-abiding citizen who doesn't want to make trouble. The moment you stop being compliant and start being politely assertive, the entire dynamic shifts. You are no longer a passive participant in your own investigation. You are an active defender of your rights. I've seen this play out with friends, with colleagues, and in countless cases I've studied. The ones who regret their decision are almost always the ones who blew at the roadside. They thought they were being cooperative. They thought it would help them. They thought the officer would see they were only a little over and cut them a break. That is a fantasy. The officer is not your judge, jury, or friend. The officer is collecting evidence. You do not help the person collecting evidence against you. You just don't. Think about the psychology of the stop. The officer has already decided, on some level, that you are impaired. Otherwise, he would have given you a warning and sent you on your way. The fact that you are standing on the sidewalk answering questions means you are already in the net. The only question is how much evidence you provide to tighten that net around you. The breath test is the final and most damning piece of that puzzle. And let's touch on the lose your license threat one more time because it's the psychological masterstroke. What the officer doesn't tell you is that if you blow and you're over the limit, you're going to lose your license anyway, at least temporarily through the criminal process, and you're going to have a criminal record. So the choice isn't blow or lose your license. The choice is lose your license with a possible criminal conviction attached, or lose your license temporarily while you fight the criminal charges. It's a completely different risk assessment. I remember driving through the Midwest a few years back, and I got pulled over for a taillight out. It was legitimately out, I knew it. The officer was polite, I was polite. He asked me if I'd been drinking. I hadn't had a drop. But in that moment, I realized how quickly things can escalate if he decides he smells something, or if I seem nervous. If I had been nervous, if my hands were shaking, he could have used that as reasonable suspicion to dig deeper. It was a stark reminder that the traffic stop is a volatile, unpredictable situation. So, going back to that guy in the airport, I wanted to walk over to him. I wanted to grab him by the shoulders and tell him to calm down, to tell him that he had options. But I also knew that his panic was the exact reaction the system is designed to produce. It's designed to make you choose the lesser of two perceived evils, without telling you that the perception is skewed. The evil of losing your license is immediate and scary. The evil of going to jail is also immediate and scary. But the path of refusal, the path of asserting your rights, delays those consequences just long enough for you to get a professional in your corner. That's really what this boils down to. It's about buying time. It's about moving the chess game from the highway shoulder, where you have no pieces on the board, to a courtroom, where you can have a knight and a bishop and a queen in the form of a skilled attorney. The officer has all the power at the roadside. He controls the lights, the traffic, the narrative. The only power you have is the power to say, I would like to move this conversation to a different venue, where the rules are different and where I have representation. And let me be clear about something else. This isn't about being anti-police. I have immense respect for the job they do. They put their lives on the line every day to keep our roads safe. But their job is to enforce the law. And your job is to protect yourself within the framework of that law. It's not personal. It's a system of checks and balances. The officer is the check on impaired driving. The Constitution and the courts are the check on the officer. Your lawyer is the guide to help you navigate that balance. I've had people tell me, well, if you're innocent, you should blow. You have nothing to hide. That sounds good in theory, but it ignores the reality of the machine. Portable breath testers have error rates. They can be contaminated by mouth alcohol from breath mints or recent burps. They can be affected by certain medical conditions, like acid reflux or diabetes. You could be perfectly sober, blow a false positive, and now you're spending the night in jail proving your innocence, rather than spending the night at home with your family. Why would you introduce that risk? Why would you trust a machine that hasn't been calibrated in 6 months over your own freedom? The argument that, if you refuse, you look guilty is also a trap. To whom do you look guilty? To the officer? He already thinks you're guilty, or at least he thinks he has enough to make an arrest. To a jury? The jury will never hear about your roadside refusal in most states because it's not admissible as evidence of guilt. It can't be used to show consciousness of guilt. The law recognizes that people refuse for many reasons, including the advice of counsel and a desire to avoid unreliable testing. So that argument evaporates under scrutiny. So, what have we really learned here? We've learned that the binary choice presented to you at the roadside is a mirage. It's a high-pressure sales tactic dressed up in a uniform. The real choice is much more complex and much more favorable to you if you know the rules of the game. The real choice is between immediate compliance and strategic delay. And this is the part I really want you to take with you. The next time you see those flashing lights in your mirror and your heart starts to pound, I want you to remember one thing. The most powerful word in your vocabulary in that moment is not yes, and it's not no. It's lawyer. Not shouted, not demanded, but calmly and clearly asserted. I would like to speak with my lawyer. That phrase, that simple sentence, changes the entire trajectory of the interaction. It signals that you are informed, that you are aware of your rights, and that you are not going to be a passive participant in your own prosecution. The officer may not like it. He may get frustrated. He may tell you that you're making a mistake, but he cannot legally punish you for invoking your rights. The consequences you face, the arrest, the booking, the temporary license suspension, are the same consequences you would face if you blew a 10. The only difference is the evidence package he takes with him to the prosecutor's office. In one scenario, he has a nice, clean, portable reading. In the other, he has a witness who may have had too much coffee that day and a video that may or may not clearly show impairment. I think about that guy in the airport a lot. I hope he found a good lawyer. I hope he realized that the panic he felt was manufactured by a system that relies on fear to function. I hope he learned that the law, while intimidating, is also a shield if you know how to hold it. We spend so much time preparing for our travels, packing the right bags, booking the right flights, finding the best restaurants, but we spend almost no time preparing for the one interaction that can derail our lives in an instant: the traffic stop. We assume it won't happen to us. We assume that if it does, our innocence or our cooperation will protect us. But innocence isn't a shield, and cooperation is just another word for giving evidence. The road is a complicated place. It's full of distractions, risks, and unpredictable variables. The only constant is the law, and the law is a tool. It's up to you to decide whether you want to be the craftsman or the project. So, the next time someone tells you that you have to choose between blowing and losing your license, you'll know the truth. You'll know that the real choice is between playing their game by their rules on their turf or waiting to play a different game, on a level field, with a professional in your corner. And that, right there, is the difference between being a passenger in your own life and being the driver. Stay safe out there.